So Miriam, thank you for sharing some insights.
Thank you for having me today, and want to join others in thanking PowHer and Time's Up for doing this important work in amplifying the New York State human rights law so that everyone across the state understands the breadth and depth of this important legislation. NELA New York is also incredibly grateful to Senator Biaggi and Assemblymember Simotas for championing the law at every step of the way. This is a real sea change here in New York State, and it's due largely to their efforts. So I'm just going to be highlighting some of the points in the new law as Senator Biaggi and Commissioner Fernandez ran through them, starting with this idea of liberal interpretation, which Commissioner Fernandez touched on. So it was very important to us to add this language into the law, which now says that the law would be construed liberally for its remedial purpose, regardless of the provisions of federal law. And this is really important because for many years, New York State court judges and federal judges interpreting the state law would simply apply federal principles. Many cases simply said that New York State law ran in lockstep with federal law. With this law, New York State law takes a much more protective turn by eliminating the severe or pervasive standard, by eliminating the requirement that workers make complaints of sexual harassment or other forms of harassment in order for the employer to be held liable. And so even though federal law still contains those restrictions, this language makes very clear that New York State law and therefore New York State employees are not bound by them. So, and it is our hope that going forward in many areas of interpreting the law, courts interpreting New York State law will be free to think about the remedial purpose of this law and not feel bound by all those decades of increasingly restrictive federal case law. And obviously that's going to be increasingly important as more federal judges are appointed by this administration who may have more restrictive views of the rights of workers. So another important point, which both Commissioner Fernandez and Senator Biaggi touched on, is the elimination of the 4-employee minimum. So up until this year, the only employers that were responsible for following anti-discrimination law were employers of 4 or more employees, except in the cases of sexual harassment. By eliminating that minimum, New York State really takes the lead, even more expansive than New York City law, in requiring that all employers follow the anti-discrimination laws. And for those who are concerned about, whether small employers, for example, are going to be aware of these new provisions, they're going to be covered by the law for the first time, we're grateful that Commissioner Fernandez and the State Division and organizations such as Time's Up are doing such a great job of educating all employers throughout the state. But many employees work for tiny employers. And up until now, those employees had no redress. That changes today. The law also, as Senator Biaggi and Commissioner Fernandez mentioned, now covers independent contractors. So independent contractors and other non-employees in the workplace are to be free from all forms of discrimination. In the past, that only covered sexual harassment. And the standard is that the employer is responsible if the employer knew or should have known of the harassment. So again, no longer is it required that the independent contractor or employee risk their job by making a complaint. The employer is responsible simply if the employer knew or should have known that the independent contractor was suffering from discrimination or harassment. With regard to domestic workers, the law before stated that domestic workers were free from sexual harassment only. Therefore, it was still lawful, believe it or not, to racially harass your domestic worker if you were an employer. That changes so that domestic workers are now protected from all forms of harassment. based on membership in a protected class, for example, race, national origin, and the like. Finally, the new law provides for attorney fees and punitive damages in all cases of unlawful discrimination. In the past, persons who brought sex discrimination cases could have their attorney fees paid by the employer if they prevailed. Now, persons who prevail in all forms of discrimination cases can have their attorney fees paid by the employer. This is very important because it extends people's access to legal representation, especially for low-wage workers, where the award that they might get in terms of back pay could be relatively small. It's difficult for them to get legal representation because lawyers, people who can't afford hourly rates tend to hire lawyers on a contingency basis. 1/3 of a small award may not be enough of incentive for an attorney to take on the case. With this new provision, attorneys who represent employees who prevail in these cases can get paid at a reasonable hourly rate by the employer. So this opens up the possibility for legal representation for low-wage workers across the state who are often the victims of the most egregious forms of discrimination. Finally, the law provides for punitive damages. Punitive damages are a form of damage that are designed to essentially punish the employer for conduct that consciously disregards the rights of others. Again, this is a very important element for low-wage workers because if their back pay awards are relatively small, the employer may just continue over and over to engage in bad behavior as a cost of doing business. If the employer is concerned about getting hit with a big punitive damages award, that might actually be a meaningful deterrent to unlawful discriminatory behavior. So those are, some of the high points of the law that it's important to be aware of going forward.
Thank you so much.